Okay, ready? So council's aware, we do have a student in the courtroom with us this morning. This is Miss Byers, and she is going to be taking the LSAT later on this summer, and is going to be observing court throughout the summer. So you guys may see her here. So just want everyone to know who the extra person we have in court is this morning. Mr. Trush, would you be available or able to address Mr. Jones' case first?
Yes, Your Honor, I think.
We do have him video. The jail was able to get him. I know it's a little bit early. So we'll call People versus Luther Jones. This is file number 266961. Mr. Jones, are you able to hear me okay?
Yes, sir.
All right. If I could have counsel put your cases on the record, please.
Good morning, Your Honor. The record of the people.
Thank you, Your Honor. Richard Trush, attorney on behalf of Mr. Jones.
Mr. Trush, could you tell me the status of this file today, please?
Your Honor, I think ultimately we're going to be requesting one last adjournment. This is the situation as it is. I'm somewhat loath to do this, but I don't see another way to address it. I think in principle we have an agreement in regards to this file. There's another file in district court that's set for a preliminary exam on Friday. I was cautiously optimistic that we were going to be able to resolve that. But frankly, after viewing the video of the incident in the other file, I don't think in good conscience I don't think I could advise him to tender a plea after viewing the video. We're set for a prelim on Friday. My hope is that once that prelim is over, either I'm right about this or I'm wrong, but I think it's going to give us clarity to be able to resolve this.
Okay. Mr. Rolla, do you have any objections to the adjournment in this file?
I don't, Judge, but I would also want to indicate for the record, as the courts also know, and as was discussed previously, Mr. Jones has matters of significant nature also waiting for him in another state, in Texas. And in fact, our office received confirmation a short time ago that they will not be further pressing their matters until ours are done. So where it was previously that they wanted him right away, that immediacy no longer exists.
Okay. All right. Mr. Jones, have you talked to your attorney about this?
Yes, sir.
And is that how you would like to proceed as well?
Yes, sir.
Okay. All right. So we'll set this for a plea hearing and status conference in July. And, forward at that time. So I'm assuming Mr. Trush, either that other case is going to have been dismissed or there'll be some type of agreement that would involve that other case.
Yes, my expectation is one way. I mean, we're set for exam Friday. One way or another, something's going to happen.
Okay. Sounds good. Thank you. Mr. Jones, do you have any question about how we're going to proceed with your case?
No, sir.
Okay, thank you. That's all for today, and the court's going to dismiss this time. Ma'am, can you tell me your name, please?
I think that's Miss Moses.
Miss Moses. Miss Moses, are you able to hear me?
Yes, Your Honor.
Okay. All right, we'll go on the record in People versus Ashley Moses. This is file number 256918. The record should reflect that Miss Moses is appearing today by video from Department of Corrections. If I could have counsel put your appearances on in this case.
Record, Your Honor, I told the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Miss Moses.
Thank you. Mr. Trush, how did we want to proceed? I believe this is a final status conference in Miss Moses' case today.
It is, Your Honor. We requested a trial, and the court has accommodated us by giving us a trial date pretty quickly. With that in mind, there are some issues here. I am cautiously optimistic that we can work through those. So I have not been able to communicate with Miss Moses since she's been in MDOC. I've tried to send JPay emails to her. I have not got anything back from her. I've tried to schedule video visits. The facility will not allow me to do that. Without getting too deep into the weeds, when you go in and set it up, they have to add you to their visitor list in order to be able to schedule it. It indicates that I'm added to her visitors list, but it also indicates they won't allow me to set it up. So whenever I try to set it up, it just tells me no, effectively. We reached out to the court, I think probably about a week ago, to try to get a writ to have her transported here and maintained here until we can conduct the trial. Again, recognizing I don't want to lose the trial date that we have, one, because Ms. Moses is lodged, so effectively on dead time, but also trial dates are just hard to come by. With that in mind, at least to this point, MDOC has not done that. We originally tried to get a writ to have her transported. They told us basically no, we didn't give them enough time. We asked them to transport her for this hearing to just bring her in person. They told us no, because this hearing was scheduled via Zoom, so they wouldn't transport her. We prepared another writ yesterday, I think, to have her transported Friday. We couldn't get it signed within the 72-hour window. So I think at present we have a writ prepared for Monday to try to get her transported here. If we can get her here to the jail essentially next week, I think we can preserve that trial date and still be able to proceed forward. Additionally, the prosecutor has raised to me they may have an issue with their lab person on the current scheduled trial date. I would like to discuss with Ms. Moses. I anticipate that we would be willing to stipulate to the lab. I don't think our argument here is going to be about what the substance was. But again, I don't think I could do that without discussing it with her. And then the last issue to address with the court today, the prosecutor did file a 404B notice. I've been able to go through the information and talk to him about what it is he's seeking via 404B. And at least at this junction, I don't have an objection to it. We haven't filed one, and frankly, because I think it's appropriate under the statute.
Okay, so it sounds like we are going forward with the trial. There's not going to be a plea.
Well, again, that's my anticipation, but bearing in mind that I haven't been able to communicate with her since the last hearing.
Okay.
So what I would suggest is if she is transported here and we ultimately do come to some kind of agreement, I think we probably can find a time when everyone's scheduled to do it. Or at least take the trial date down if we know that's what's going to happen.
Okay. Mr. Rolla, do the people have any problems in terms of your witnesses?
The only issue is with Mallory Smith, even though our subpoenas were served over a month ago now. As the court's well aware, the crime lab individuals are requested in all sorts of locations. Oddly enough, in this particular case, for a matter in Montmorency County, our office is waiting a call back to Ms. Cunningham's office to find out whether Ms. Smith would be testifying on the first or second day of trial. We thought we had that problem worked out until then. We found out a second subpoena, a third subpoena on Ms. Smith by the defense attorney in the Montmorency County case. And they are currently demanding her for the second day, which makes little sense for the prosecution. But in any case, I did bring it to Mr. Trush's attention. I don't believe their argument deals with what the lab report actually says. So the people would be willing to submit to the court for signature a proposed in order to allow the lab report to be admitted without Ms. Smith's foundational testimony underlying it. Obviously, I understand Mr. Trush needs to speak to his client before he can sign such a proposal.
All right, so I guess here's how we'll proceed. Number one, I'm willing to extend the plea cutoff date due to the what I regard as a lack of cooperation from Department of Corrections, despite diligent efforts by counsel to contact his client. So I don't think it's fair to not allow a plea after today, given that lack of communication. So we'll leave the trial date on with the idea that we're going forward. I'm not going to schedule any additional dates in this case. To the extent that there is a plea agreement, I know that in the weeks between now and Ms. Moses' trial date, I'm gonna be in a 2-week medical malpractice trial in Kalkaska, but I could certainly carve some time out during lunch or before or after those trial days to take a plea by video. So I will allow a late plea in this case. And I think this one is scheduled for the 28th.
I think the 29th.
The
Is
29th.
that a Monday?
29th, 30th, yes.
Monday, Tuesday, that week, or do we have-
I think it's Monday and Tuesday. Here. Yes,
And it
it's
does appear to be
Monday.
Monday.
Monday, okay, so the plea would have to, well, I'm gonna set a plea cutoff at by noon on Friday prior to, so that way, if there's gonna be a plea, we know in enough time to call out the jury and so forth.
And again, in candor, Your Honor, I would anticipate by the end of next week, I would expect that I will have a firm answer one way or another. And if she hasn't been transported by then, I think I'm likely going to have to be submitting a stip to adjourn the trial
Right.
while we figure something out. And I apologize, there is one last issue on this that I did want to raise.
Okay,
The prosecutor had brought to my attention 3 weeks ago, a month ago, somewhere in that time period, a potential conflict on the case. And that is one of the listed witnesses was also a former client of mine, that being Mr. Gallagher. Ms. Moses is aware of this. We've discussed this. When we last discussed it, I don't think she has any objection to me representing her, understanding that I did represent Mr. Gallagher previously. I've also discussed that with Mr. Gallagher as well. He also doesn't have any objection to that. I don't foresee it as a problem, but again, I just want to put that out there so that it's clear for everyone. And again, I don't view it based on what both of them have told me that their positions are contradictory here.
okay. All right, we've got that preserved for the record then. Ms. Moses, do you have any questions about any of the things we've been discussing so far here today?
No, Your Honor.
Mr. Rolla, is there anything else we need to address on this file?
I don't believe so, yes, thank you.
Mr. Church?
No, thank you.
All right, Ms. Moses, if you don't have any other questions, we're going to disconnect at this time. Do you have any questions?
No, Your Honor.
Thank you, that's all for today. Okay. Mr. Phillips, I believe is Grand Traverse, is that where he's at?
Correct.
Okay, see them connected. We do a writ on that one, Mr. Rowland?
Well, research.
Judge, I do see that we got a email from Misty with the PA's office that they did confirm 9 a.m.
Just for clarity's sake, they confirmed it was Grand Traverse because he was lodged in Leelanau for Grand Traverse, and then they transferred him from Leelanau back to Grand Traverse.
Yeah, this says confirmed with Grand Traverse County Jail for June 3rd at 9 a.m.
Okay, let me just, I'm gonna ask Jen.
Judge, looks like the written was confirmed.
Hey, can you contact Grand Traverse Jail on Brian Phillips? We do have a writ that was confirmed by them for 9 a.m. Okay, thank you.
Yeah, Judge, that was confirmed by Grand Traverse on May 28th. This month.
Okay. All right, is Mr. Slating present?
Yes.
Mr. Slating, if you come forward, please, we'll go on the record in People versus Slating. This is file number 266955. The record should reflect Mr. Slating is present here in the courtroom today. This is the date.
Thank you, Your Honor. Richard Shoestring on behalf of Mr. Slade.
This is the date time set for sentencing in this matter. Mr. Slading, did you have an opportunity to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, we have discussed it, yeah.
Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rowland, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring? Anything on behalf of the people for allocution today?
That's just a situation, obviously, in light of the nature of the offenses specifically. Although I understand it's an operating while intoxicated, the controlled substance second. He also had a situation where he's in possession of a weapon. If I recall correctly, in this particular matter, I believe this is one where the defendant actually was stopped with 57 originally in the 30 zone. And then it was only after he found out that his vehicle would be searched that then the defendant admitted the weapon, in this case, a set of brass knuckles, were located in the vehicle. His blood alcohol is a 133. This is a circumstance where, in this particular case, we're dealing with the defendant's third felony situation. And I think the sentence by the court should have to reflect that. Thank you.
Thank you, Mr. Trush. And just so the council's aware, both sides, I did get the packet of information regarding Mr. Slading's treatment and counseling.
And Your Honor, I have just a few additional pieces of information that came in just yesterday from his doctor. I provided this to the prosecutor this morning.
And I did get the record that they were handed to myself this morning. I reviewed the same, I have no objection for taking the witness.
Okay, Mr. Trush.
Thank you, Your Honor. Ultimately, I think the recommendation here is appropriate for a variety of reasons. I think the recommendation as it's written to impose jail but hold it in abeyance balances the factors here in an appropriate way and is well tailored to Mr. Slading. I haven't had a client who I've had more, I think, positive communication with throughout the case, and I think this bodes really well for it. Since this has happened, he, to me, has demonstrated he's an excellent candidate for supervision as opposed to incarceration. Mr. Slading, after this happened, recognized, hey, I've kind of gone down a bad road, fell into some old habits, some old patterns that are not good. He got himself into a treatment setting with Easter seals, and the court has some of that information. And he has been diligent with that. Even though the alcohol-related offenses, the lesser of the offenses here, again, I think he recognizes that that's the problem that led him down this road, right? He got himself involved in that. He's been diligently working on that, as well as the mental health side of things too. So he's been addressing some of the mental health stuff he has, as well as diligently addressing the drinking. He's stayed in great communication with me. He's been fully compliant with community corrections. Maybe the most telling thing, and again, this is a truly remarkable thing for me, is he had a medical emergency prior to our initial scheduled plea hearing where we intended to enter into a plea agreement. He has a medical emergency and he is about to go into emergency surgery. He doesn't know if he's going to live or not. And what does he do? He contacts his attorney and tells him, hey, I'm not going to make it to court. I think the court could probably recognize that there are not a lot of people who would do that in that circumstance. I think a lot of people would, one, not even think about it in that circumstance, or if they were thinking about it, probably wouldn't even take the action and go, this is a good excuse to not do it and just not do anything. I mean, the fact that he made that communication at that time to make us aware of what was going on in that emergency situation, I think speaks volumes to him. It shows how seriously he's taking the matter. And again, I think it shows that he is an excellent candidate for supervision as opposed to incarceration. If we set that aside for a minute, I think we also could look at, again, his specific medical circumstances. Because of the medical emergency that he had and is still dealing with, and that indicates he has a follow-up surgery later this month to reverse some of what they had to do. Not to mention he has a long road of recovery down the road after that to get back to normal life. Although he's on the right track, some of his restrictions have been removed, I think, already, so he's progressing. But I think those medical circumstances also warrant the court looking at, is jail the right option here? Because he's at a extremely high risk if he's in the jail for things like infection. And obviously that's not good for him, but frankly, it's not good for the jail either to have somebody in there that needs that sort of extra higher level of care. And again, it's also a liability risk to jail. Beyond those two things, I think the nature of what happened here doesn't support what I would frame as an overreaction from the court. We see these things from time to time where we have these weapons charges with what I think of as sort of non-traditional weapons. And I mean that because when we often look at these, what we think of is a knife or a gun. But we have some of these other things that come up from time to time. Again, for example, like switchblade knives or butterfly knives, which people don't necessarily recognize are illegal for them to carry. And these are very frustrating cases for me, and I think for many of my clients they are too, because the court probably recognizes if you drive up and down I-75 and stop at any number of gas stations, rest stops, truck stops, these items are readily available for sale at the counter. To a lay person, they probably don't recognize at a fundamental level that it's crime, but at an even more fundamental level that it's a felony. Now, I think for Mr. Slating, the calculus here is probably a little bit different because he has some felony history, so he knows he's not supposed to possess weapons. So I think that sort of dovetails into when the police ask him basically, hey, is there anything in the vehicle? He says, his report says, kind of puts his head down and says, yep, I've got brass knuckles. And I think he recognizes that he wasn't supposed to have weapons. But again, I don't think most lay people recognize that these things that are so readily available are not just illegal, but illegal to that level. With that in mind, again, I think the recommendation here is well written. I think it's well tailored to his specific circumstances, both in terms of his history, what he's done while the case is pending, his medical circumstances, and the circumstances of this event. So we would ask the court to follow that recommendation and give him an opportunity to show the court this isn't reflective of who he is, and show that he can be successful. Thank you.
Thank you. Mr. Slating, anything you wanted to say today?
Just that I appreciate the patience that everyone's had with me. I'm obviously up here to take care of what I owe to the state, and I apologize to the city of Gaylord for, creating a nuisance of myself when I did come up here. I'm just trying to get better. This was life altering for me with the colostomy and the bag and the pain I went through for it. It's just, you have a better appreciation for life. And I've got a couple of grandbabies that were just born, and I kind of want to spend some time with them. So I'm going to continue working on myself mentally and physically, get myself better again.
All right. Well, I did read through the report, Mr. Slating, so I'm familiar with what happened in this case, brings you before the court here today, as well as your circumstances and background and so forth, based on what's written in that report. I take all of that information into consideration. Again, I did review the documentation that was provided previously regarding your conditions, as well as what was provided here today. Certainly take that into account along with what you've had to say and what the lawyers have had to say. I agree with Mr. Trush, even though it is the lesser charge here, I think the bigger concern is the operation of the vehicle and the manner that you were operating in it and the condition that you were in. Because in my view, that creates a much bigger concern for public safety than having some brass knuckles. Although, as Mr. Trush indicated, as someone with a prior record, you were or should have been well aware that that's not something you can have. And so when I look at the aggravating factors or the things that make this worse versus the mitigating factors, certainly the operation of the vehicle at that speed presented a danger to the public. And to some extent, I think we're all lucky that nobody was hurt, including yourself, during your operation of the vehicle that night or that day. But at the same time, I look at what have you done since then, and based on the documentation, it does appear that you're taking that issue seriously and that you sought some pretty intensive treatment to help deal with that, and more importantly, from my perspective, to prevent that from happening again. Your medical conditions are a consideration. However, to me, that's much less a consideration. I have frequently people who have medical conditions that come before me, and that's not a reason not to impose jail or prison time. It's just not. But what's more significant to me is the efforts that you've undertaken to get treatment, get help, to deal with the underlying issues from a psychological and substance standpoint. So I do think the recommendation is well crafted. I think it builds in some punishment, which if you're not doing what you're supposed to be doing is significant. So I hope that provides a degree of motivation to you. It provides, in my view, maybe one of the most important things, which is oversight and supervision, some testing to make sure that you're on the right path and that you're staying on that right path and not presenting a danger to the public. And to the extent that you don't stay on that path, I'm going to have no qualms, regardless of your medical condition, of imposing jail time. Because at that point, you're going to have said to me, basically, that your medical condition and those other things aren't as important. And so if they're not that important to you, they're not going to be that important to me. So I am going to follow the recommendation. I'm going to sentence you to probation for a period of 2 years. The court will adopt as the conditions of that probation all the terms and conditions that are listed in this report. And that includes completing any substance abuse treatment that you're in or that is recommended to you by your probation agent, that you not use or possess any controlled substances unless they're prescribed to you, that you comply with alcohol testing as directed by your agent, and that you not use or possess any alcoholic beverages or other intoxicants, along with all the other requirements. The court is going to impose 12 months in the Otsego County Jail with credit for 2 days served. The court will hold that time in abeyance to be served at the discretion of the court. And so what that means, Mr. Slating, is if you violate your probation in any way, I can impose that 12 months without a hearing, do not pass go, straight to jail. And that's in addition to additional penalties for the actual probation violation. So I want you to understand that if you violate, it's not going to be, 6 months down the line and finally there's a consequence. That consequence will come immediately. If you do comply, and I hope that you do, and then you follow through with what you're doing now and continue on the path you're on now, you won't ever have to serve that. The court is going to order a crime victims assessment of $130, supervision fee of $30 per month while you're on probation, court costs of $325, attorney fees of $350, a $68 state cost. And that all is in relation to the weapons charge. On the OWI second, the court is going to order also 12 months in the Otsego County Jail, credit for 2 days served, that time to be held in abeyance, fine of $500, a $50 state cost, and an OUIL reimbursement of $200. You have the ability to seek an appeal of this sentence. Oh, one of the conditions too is specifically no use of the substance kratom. You do have the ability to seek an appeal of the sentence, and Mr. Trush, if you can provide an acknowledgement of the appellate rights. Ms. Davis, is he going to meet with you here today?
Yeah.
Mr. Phillips, are you able to hear me okay?
Yes, I am, Your Honor.
All right, we'll go on the record in People versus Phillips. This is file number 226358. The record should reflect that Mr. Phillips is appearing today by video from Grand Traverse County Jail. If I could have counsel with your appearances.
Gentlemen from the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Phillips.
Thank you. Mr. Trush, can you tell me the status of this file here today?
Your Honor, we have made some good progress since the last hearing. Mr. Phillips had requested the first time I spoke to him to be able to review the video footage. I was able to obtain that from the prosecutor's office. I was able to get a video call set up with Mr. Phillips so I could share a screen so he could view the video from the jail there in Grand Traverse. We were able to have him view, I think, most of the video as well as have some discussion. He'd ultimately indicated that he would like some additional time. Said, it's a big decision for me to make after having gone through the video. We also discussed some case law issues about the ultimate search of the vehicle. So ultimately, I think we will be requesting one final adjournment on this matter. So Mr. Phillips can make a final decision as to whether or not he wants to accept the offer that's been tendered or have the matter docketed for a trial. And that's the status of where things sit right now.
Thank you, Mr. Rowland.
Yes, Judge, there is a plea offer extended currently as to count one without enhancements. People have no objection to one further adjournment. The material in question, the alleged substances, has already been tested. The defense has provided all that information.
All right. So, Mr. Trush, I think it's been just over a month since you came on this case. Is that right?
Yeah, I think about 6 weeks. The first hearing was almost immediately after the appointment.
Okay.
Judge, for the record, the substitution counsel was signed on May 5th.
Okay. So I think it's fair, even though this case is quite old, given Mr. Trush's late involvement, to allow a little bit more time. So the court will set this for a plea hearing in July. So Mr. Phillips, between now and that hearing in July, I know Mr. Trush will be in touch with you. You need to make sure that you communicate with him. At that next hearing, I'm going to be asking you for a final decision about whether or not you want to enter into a plea agreement. If you do, then we'll go forward with that plea on that date. If you do not want to enter into a plea agreement, then we'll set it for trial and the court will not accept any pleas to any lesser charges after that date. So you need over the next month to make sure that you're prepared and ready to go with the final decision. Do you understand that?
I do understand. I'm yet to even receive a police report on this matter. I have not, he says, my attorney said that he set up a meeting. The guards here at the Grand Traverse County Jail made me get off the tablet. I only got to view the footage for maybe 10 minutes. I did not get to watch it any further than that. I've tried to contact Mr. Trush's office and I've not been able to contact him. He told me that he sent over a police report, never got it. So I don't feel like I can consciously make a decision if I don't have the information before me. I realize that the case is old, but even when I had Mr. Gilo as an attorney, I couldn't get through to him. Never got a police report from him. I don't know what to do.
All right, well, I'm just not going to give you any more time. You got a month. This case has been pending since 2022. You disappeared for 4 years. If you were that worried about it, you know, you would have taken care of it between now and then. So
I tried to contact the prosecutor's office out there. They told me I had to go through my attorney, Mr. Gilo, who would not accept my calls, even when I was not in jail.
no,
I'm
I'm
not
sure it's
trying to make
everybody
any-
else. Yeah,
I'm not
no, I'm
trying-
sure it's everybody else's fault, but I'm
No, that's
telling
not what
you.
I'm saying.
Oh,
That's not what I'm
sounds
saying
like
at all. No, I promise that's not what I'm saying. I'm just saying I have not even received a police report on this matter. So I don't even know. I don't know. I guess I don't know.
Okay, well, you've had 4 years to figure it out, so you've got 30 more days. And if you don't want to accept the plea at that time, then we'll set it for trial and we'll go forward that way, okay?
Your Honor, I'll reach out to the jail and communicate with them about how to get the report over to them.
Okay. All right, that's all for this hearing today. We're going to disconnect at this time. People versus Tony Harris, file number 266982.
Thank you, Your Honor. Richard Trush hearing on behalf of Ms. Harris.
Mr. Trush, can you tell me the status of this?
Yes, Your Honor, we are in receipt of an offer from the prosecutor's office that we tend to accept. I apologize, I'm looking for it. It's
Judge, perhaps I can give some assistance in this particular case. Ms. Porter from our office agreed to back on a month ago to an offer of additional 2 counts of financial transaction device fraud. Contract MCL 750-157-10-1. That's a 4-year, $5,000 each felony. In return, that would be counts 9 and 10. In return, counts 1 and 8 would be dismissed.
and that's correct, Your Honor.
Is there amended in the information I have is 8 count information.
Right, these
Right, Judge.
would be an added count
It's
9.
the added counts 9 and 10.
Sorry.
And Your Honor, we would be intending to enter into that agreement. We'd be asking the court to consider setting the sentencing about 60 days down the road. Ms. Harris is having some housing issues right now that she'd like to be able to resolve prior to the sentencing date.
And I was writing something else. So the added count 9 and 10 are charges of what?
And it would be financial transaction device fraud, Judge, improper use or possession. And the PAC code is 750-157, and it's in Nancy 1.
And the maximum penalties.
That is it. They are both 4-year, $5,000. Class H is in Harold.
Okay, thank you. All right. Ms. Harris, have you had an opportunity to speak with Mr. Trush about this agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Ms. Harris, are you currently on any kind of probation or parole? And you understand that by pleading guilty to each of these charges, that the maximum possible penalty you could face would be up to 4 years and or a $5,000 fine.
Yes, sir.
With those things in mind, what is your plea to those 2 charges today? So right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want to. You understand all those rights. You understand that you're giving up and waiving all of those rights by pleading guilty. Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what was said here in court today? Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty of these crimes?
Yes, sir.
Thank you, Mr. Trush. I'm going to ask that you conduct some questioning here on establish some actual basis.
And Judge, for the benefit of the court, since a check is a financial transaction that's for the statute, I'm simply ask that you have that information prior to taking the rest of the facts. Okay, thank you.
Deputy. Yes, that's the next.
So, Ms. Harris, do you live here in Otsego County?
Yes.
And were you living here in Otsego County in November of 2025?
Yes.
And in November of 2025, were you doing work for a Martha Jo Decker?
Yes.
And did she pay you for that work with checks?
Yes.
And did you alter the checks before cashing them?
Yes.
And so she wrote something on the checks and you altered what she wrote?
Yes.
And did that happen on at least 2 occasions?
Yes.
And those checks were cashed here in Otsego County?
Yes.
I think that would establish this.
Judge, one additional, if I may.
Sure.
That the defendant was given no permission to alter those checks.
Is that correct?
Yes, sir.
Thank you, shall the people satisfied the court has sufficient explanation to accept the defendant's guilty pleas to added counsel and sentence.
Thank you. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
None by the people, thank you.
None, Your Honor.
Are you both satisfied that the court has complied with statute, court rule, in the taking of this plea?
Yes, Judge.
Yes, Your Honor.
Thank you. Ms. Harris, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Mr. Rolla, do you have any objection to setting that out 60 days?
No, Judge, and again, this will, the court be able to look at the restitution in this case.
Okay, so we'll set it for about 60 days. You'll get notice of the date and time of that hearing. It's important that you stay in touch with Mr. Trush between now and then so that you're prepared to go forward on that day. And before you leave today, you're going to meet with Ms. Davis to set up a time for the pre-sentence report. Okay. Thank you. Mr. Spence. Sir, if you come over to the podium, please. We'll go on the record in People versus Spats.
I'm trying my phone to the council people.
Thank you, Your Honor. Richard Truish, on behalf of Mr. Spence.
Thank you. This is the date and time set for sentencing in this matter. The record should reflect that Mr. Spats is present here in the courtroom today. Mr. Spats, have you had an opportunity to go through the pre-sentence report and talk to Mr. Truish about that?
Yes, sir.
Mr. Truish, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Judge, thank you.
People have any challenges to the scoring?
We do not.
Anything I should ask for people for allocation?
Yes, Judge. This is a situation as indicated with the police report, we have the probable cause and reflected in the PSI. This was found in the vehicle after a hit and run that took place actually in Grand Traverse County in Tuscarora Township. So we had kind of a divided, as the court saw from the PSI, and divided investigation and prosecution. In this particular case, these are the defendant's fifth and sixth memories. The defendant, as already indicated, fled from the hit and run accident during which he was intoxicated. He's got 2 prior weapons felonies, as indicated under items 1 and 11 of his adult record, and 5 prior apparently intoxicated situations. He was intoxicated in this particular case where it was either by alcohol controlled substances, reflected under items 2, 3, 4, 9, and 11. He also has a prior situation history failing to appear in bail jumping. And again, it's a circumstance where this case the defendant was had a high volume of traffic situation when he chose to take the offenses. Under the circumstances, the guidelines in this case are 12 to 30 up to 7.5 years, or 7 to 28 up to 6 years. And I think this position, the defendant presents a direct threat to the community unless he's locked up. I think the court needs to take that into consideration.
Thank you, Mr. Truish.
Thank you, Your Honor. I think there are several things for the court to consider here. Frankly, ultimately, I think the recommendation here is appropriate. So the first thing I would ask the court to consider is, as the prosecutor sort of alluded to, the circumstances here sort of led to a bifurcated prosecution where there was first a prosecution in, so is it Petoskey? In Sheboygan, where he served a chunk of time before ultimately being transported here, where this case then began. So again, the total time he's been incarcerated, frankly, is longer than what's reflected here in credit. And not to suggest that he necessarily is entitled to credit for that, but I mean, this is one series of events. Additionally, and I think, frankly, probably to me, the most compelling argument here, I'm not going to suggest to the court that the behavior here is appropriate or safe, because I don't think it is. But I think that the circumstances here really do warrant what's recommended, which is to say Mr. Spats does not have any real connection to this community. Mr. Spats, frankly, if the court were to send him to MDOC, all that this would likely do is impose an additional burden on the taxpayers of Michigan for really a very limited purpose, I think, which is to say there's a hold on him out of Indiana. They're coming to get him. They want to get him from communications with Ms. Davis, as well as the jail here. I mean, they have a hold on him. They're ready to come get him as soon as he's available. In Indiana, he reports to me that he's looking at most likely a 3-year sentence in Indiana's Department of Corrections. And frankly, when he's done there, or while he's there, he still, I think, has a matter out of Wisconsin he has to deal with. Again, I'm not going to suggest to the court that any of this is okay. I think Mr. Spats needs to get the substance issue under control. I think this situation, everything he's got going on, is a clear indicator that he has a problem he needs to address. The question I think that the court has to answer here today is if the court, for example, were to send him to MDOC, does that really further any of the purposes in which we're here for? Which is to say, our purposes here are to punish the behavior, potentially to look at the protection of the community, and potentially to look at rehabilitation, right? These are the things that we're looking at. I don't think, given these circumstances, that the court really has much ability to further any of those goals with that type of sentence. I think that the appropriate steps here are to sentence him to a county jail sentence, to make him eligible for Indiana to come and get him. If he serves 3 years in Indiana, then he serves his 3 years there in Indiana, Indiana. Then he's got to deal with Wisconsin, and ultimately he's either going to get his stuff together or he's not. He's either going to address his substance abuse issues or he's not. Again, I don't see how incarcerating him here in Michigan Department of Corrections really furthers the goals in any meaningful way. I think everybody's goals are more furthered by getting him to get these other matters resolved so that he can take care of the things he needs to do to get back to being a productive member of society.
All right, thank you. Mr. Spatz, anything you wanted to say?
Go for it.
Mr. Spatz, I did look through the pre-sentence report very carefully. I read through all the information in that report. That report contains, of course, a description of what happened in this particular case, what brings you before the court here today, as well as your past, your background, and your circumstances, prior convictions, and so forth. So I take all that information into consideration along with what the lawyers have to say as well. And number one, this was a dangerous situation, could have resulted in injury or death to yourself or other people. You encountered you on the road that day, as well as law enforcement officers that were involved in this incident, which spanned, a couple different counties. So I think certainly your conduct in this case deserves a degree of punishment. When I look at your past record, you've got a number of different charges involving weapons, involving this kind of conduct. And so far, I was really surprised to see kind of how lightly you've gotten off on some of these charges, which look fairly serious. You had some short jail sentences, and when I say short, I think one was well over 200 days, but fines, and none of that seems to have made an impression on you or gotten through to you, and you're continuing to offend, not just here in Michigan, but in other states. And I do think there is something to be gained. You committed this crime here in Michigan, you got the answer for this crime here in Michigan. And I think that punishment certainly warranted in this case. And I think from a deterrent standpoint, lighter sentences, community supervision haven't been successful in deterring your conduct. And so I think a harsher sentence is necessary to try to accomplish that. So the court I take note that as to the weapons offense, the guidelines are 12 to 30. As to the possession of narcotics, it's 7 to 28. So the court finds that a sentence within those guidelines is appropriate. The court is going to sentence you on the weapons offense to 24 months to 7 years, 6 months in the Michigan Department of Corrections. You do have credit for 103 days served. On the possession of narcotics offense, 24 months to 6 years in the Michigan Department of Corrections with 103 days served. Those sentences to be served concurrent to each other. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and $136 state costs. You do have the ability to seek an appeal of this sentence, and Mr. Trush can provide those appellate rights to Mr. Spatz.
Judge, court ordering for statute, condemnation of gun and ammo pushing of NCL.
Yes, the court will order forfeiture.
Your Honor, is the court going to make him available to Indiana?
I mean, I don't know, Ms. Davis, can you help me out with that? I'm not
Both
sure.
will go with him, and then when he comes up with the parole board, they'll contact Indiana. And then Indiana will come and get him from prison.
Okay. So I think that's our answer. All right, Mr. Spatz, you are admitted to the custody of the state at this time.
Judge, I'm sorry, the last part that you said, was it the forfeiture of the weapon?
That's the way-
Okay, thank you.
Our next matter is Mr. Madden's case. He's got to be brought up from the jail. Ms. Messer, it might just be a minute. We've got to bring up Mr. Madden here to the courtroom.
Yes, sir.
So I'm just going to take a short recess and we'll come back on the record as soon as Mr. Madden's here.
Sounds good.
Okay, we'll go on the record in People versus John Michael Madden. This is file number 266973. The record should reflect Mr. Madden is present here in the courtroom today. If I can have counsel put your appearances on.
Ashley Messer for the people, Your Honor.
Thank you, Your Honor. Richard Trish appearing on behalf of Mr. Madden.
Thank you. This is the date and time set for sentencing in this matter. Mr. Madden, have you had an opportunity to go through the pre-sentence report with Mr. Trush? Yes, sir. And Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring?
Well, actually, I do want to raise one thing. We're not going to challenge it today, but I just want to make a record to make the court aware of it. Mr. Madden indicates that entry 8 of 16 on the adult history, which is listed as a low severity felony. He indicates to me that he does not believe that that's a felony. I had an opportunity to go through with Ms. Davis today the interstate lien. It appears to be a felony on there. We're not going to be challenging that today. If it were a misdemeanor, it would change his guidelines from 2 to 17 to 0 to 9. Again, I've discussed that with him. He's indicated that he intends to, after today, contact that state and work out that with them. But again, I just want to make it clear that it's an issue that's on our radar, but we're not challenging it today.
Okay, so that is preserved for the record then. But you said other than that, there's no challenges to the scoring.
Correct.
Ms. Messer, do you have any additions, deletions, or corrections to that report?
I do not, Your Honor, and I have verified that the amount of the arrearage is listed in my page 2. I believe it's under descriptive narrative offense, that $26,318.68. I have verified that that's correct.
Okay, thank you. Do you have any challenges to the scoring?
I do not, Your Honor. Thank you.
Do you have any victims that wish to address the court today?
Your Honor, Ms. Brown is the victim. She has appeared at court before when we conducted our preliminary examination, so I'm not sure if she is in the courtroom. I know that she has been involved in the case.
She is not present.
Your Honor, I appreciate the court checking on that. Thank you.
Anything that you would like to say by way of allocution on behalf of the people?
Yes, Your Honor. This one's a little difficult. Normally, we would always ask for community supervision to meet the goals of our cases, which is to bring restitution to the victim in an attempt to make them whole. This one's a little different, as it appears that Mr. Madden has not done very well with prior instances of community supervision. So I'm not sure what the prospects of him being successful if the court were to place him on another term of community supervision. And it does not appear that he has made any payments in at least 6 years. So I'm not sure of his intentions to really make the victim whole or to do so here. So this one's a little tough for me. So I would leave ultimate sentencing with the discretion of Your Honor. Thank you.
Thank you, Mr. Trush.
Thank you, Your Honor. Ultimately, I think the prosecutor and I are kind of on the same page on this for different reasons. I agree this is probably one of the most unique cases that I have had. This case is incredibly unique because what we have is really sort of a tale of two halves, right? We have up until, I think it's either 2012 or 2014, we have consistent payments being made. Mr. Madden is working, he's working in a union shop, he is getting paid, and they are withholding income out of his payments. Payments are being made consistently. Then we have the payments stop. What happens? We provided the court some information that he hasn't been able to work for a long period of time, but he has an injury on the job. And as a result of the injury on the job, he has a surgery, and that doesn't fix the problem. He goes in and has another surgery, which goes very bad. This surgery essentially leaves him unable to work. And since that time, he has not been able to work. Now, the court can look at the payment history, and I think it's pretty obvious what happened, right? He has this injury. He is not able to work. He gets a lump sum payout of, I think, about $60,000. about 28,000 or 30,000 of it is then taken for the child support arrearages, and you'll see those payments again. I think those are in 2015. You'll see, I think, a 7, a 14, and a $7,000 payment are taken out of that settlement for the child support. From that point forward, Mr. Madden has not had any ability to work. Now, I say all of this because I do think that there is some fault here that falls to Mr. Madden, and I think the court should really be looking though at what is the behavior or what is the failing here that we should be looking at. And I think the real failing here from Mr. Madden is something that unfortunately we see from time to time is system frustration, right? At this junction, as an attorney, I think there's a pretty clear path of what he should do. Right, the clear path of what he should do is he should communicate to friend of the court. I'm not able to work, communicate the health information to them, and basically be going to friend of the court to adjust what he's paying, if anything, in child support arrearages. And I think Mr. Madden starts that process. Problem is, institutional fatigue, right? He gets to the point where he's not getting anywhere with that, and he just kind of stops. And obviously that puts him in the position he's in today, right? The arrearages keep accruing. He has no ability to pay it. And he does, again, what any number of people we see here do. He kind of puts his head in the sand and, doesn't do anything with it. And frankly, we see this pattern for Mr. Madden repeat. He goes through the disability process. Court's probably aware it's not my area of practice, but this is a process that's a long time. And frankly, my understanding of it is through the disability process, you go through a whole lot of no's to finally get to a yes. And he didn't follow through all the way to the end of that process. So now he's in a position where he's physically unable to work. He does not have any income of any kind. And frankly, he reports to me that the attorney for disability has reported to him that because of statute of limitations type things, the injury that caused all of this, he no longer can seek disability for because he filed the claim and hasn't basically followed everything up for such a long time. He can't sort of reopen that claim. Not my area of expertise, but sounds consistent with what I expect the law would say. All of that in mind, right? What is the right answer here? And I appreciate Ms. Messer. I think she's sort of in the same boat that I am. I think if the court were to put him on probation and tell him, hey, you've got to, make your monthly child support obligation, you've got to do this and this and this, it's probably a recipe to set him up to not be successful and to be back here with probation violations and really just go down a road that I don't think benefits anybody. I don't think it benefits the victim. I don't think it benefits the community, and I don't think it benefits Mr. Madden. What we have here is one of the truly unfortunate circumstances. I mean, Mr. Madden goes from being a healthy, physically able individual. I mean, he reports to me that at the time of the accident, he was about 200 pounds of pretty solid muscle. As he sits here before you today, probably 150 pounds, maybe. I mean, he quite literally, he can't physically do work. And it's difficult because you look at him and does he appear to be disabled? And I think the answer would be there's nothing here that stands out and jumps and screams. He's not physically capable. But that's the difficulty with pain. I mean, the surgeries that he had were on his neck. We can't see the pain that he experiences, and frankly, everyone feels and experiences pain different. But the doctors indicate he can't do the work. I would suggest to the court, in this particular circumstance, I think the right answer here is a term of incarceration in the county jail. I think the term that he has served to this point, to me, would seem to probably be an appropriate amount of jail for what's really happened here. This is one of the truly unique cases I've had as we explored the impossibility defense for a potential trial. I'm shocked at just how much is necessary for that defense. I mean, you have to basically prove to a jury that you took necessary and appropriate actions to take into account potential emergencies that were unforeseeable. I mean, it's pretty remarkable. But I mean, he's pretty close to that point. I don't think he has any ability to pay. I don't think if the court orders probation and orders him to, you know, make payment obligations, that we're doing anything other than setting him up to be back here in 3 months, 4 months, 6 months, whenever it is that probation has decided it's the time to, you know, file the violation. Because he can't do it. It's not something he can do. I think that it is appropriate to order county jail, because I think there does need to be a response for what's happened. I think the amount of time that he served is probably an adequate marker for what's gone on here. And that's what I would ask court to consider.
All right, thank you, Mr. Madden. Anything you wanted to say today?
So he's covered me.
Okay, I read through the report, so I'm familiar with the circumstances that bring you before the court here today. I'm also familiar with your background and your circumstances based on the information in that report. I did get a letter, I think that Mr. Trush forwarded.
And it's from his wife.
From Catherine. Yeah. And I got a letter from 2018 from Covenant Healthcare about her medical condition. So I take all of those things into consideration along with what the prosecutor and Mr. Trush had to say on your behalf. And I mean, I agree, it's difficult to figure out what's the appropriate way to move on here. You know, ultimately the goal is to get this arrearage paid off, because it's money that you owe that you should have paid that you didn't pay. You know, I get the institutional fatigue argument, but the fact is there are thousands and thousands of parents who pay child support every month here in the state of Michigan. Not all of them are in perfect health or have perfect circumstances. And the fact is that 99% of them work with the friend of the court, and they end up making their payments or getting those payments abated or reduced. And there's a small percentage of people that we see here in court who just ignore it. And that's what happened in this case. I don't know what's going on with your disability and why you didn't get it or should have gotten it. Again, you know, I think all of that falls squarely in your court. If you're not able to work, you know, I don't know what else you were doing that you were so busy that you couldn't take care of the child support issues and try to get that mitigated or take care of your disability. It seems like you should have plenty of time on your hands to do those kind of things, regardless of institutional fatigue.
Sorry, I had given them documentation of my.
Oh, I'm sure you've done everything you could. Yeah, that's why you're here. If you had done everything you could, you would be here. And I know for a fact that friend of the court and the state don't bring these kind of charges unless it's the absolute last ditch effort to get somebody's attention. So I'm fully satisfied that you've had more than enough opportunities. This has started in 2014 to take care of this in a different way. And you didn't, that's why we're here. So I don't believe that it's anybody else's fault except yours. And again, if you can't work, you've got all this time on your hands to work on this stuff. It doesn't take any physical effort at all. It just takes a little bit of diligence. You can do that. So I don't think just giving you 140 days in jail and then letting $26,000 just go by the wayside is the right way to go forward here. I think that gives you an easy out for years and years of payments that you didn't make, and then somebody else had to take up the slack because you weren't doing it. And I think that's far too easy of an out with that kind of arrearage. You know, if we were talking about a smaller amount that you want, $26,000, to just completely let you out of that obligation is not appropriate. So The court's gonna hold your feet to the fire and place you on probation for a period of 2 years. I'm gonna adopt as the conditions of that probation, all the terms and conditions listed in the report. The court is going to impose 12 months in the Otsego County Jail, credit for 149 days served. I will hold the remaining time in abeyance, so you'll be released immediately today. Again, because the goal here is to get some payments made towards this arrearage. In terms of those payments, I'm going to leave that to the discretion of your probation agent. The court is going to order that payment to be made monthly towards the arrearage, but your probation agent is going to be the person in the best position to determine how much you can make towards those payments on a monthly basis. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350.
Your Honor, may I suggest this might be a case it's appropriate to waive the attorney fees to the extent that we can get some payments made. I'd rather they go to the child support than, well, not directly to me, but effectively to me.
Yeah, I agree with that. It's a good suggestion, Mr. Church. Thank you. So the court's going to waive the court costs and attorney fees. But I am required to impose by statute the crime victim's assessment, the supervision fee, and $136 state cost. You do have the ability to seek an appeal of this sentence, and Mr. Church can provide those, and that's going to apply to both in this case. Yes, sir. Thank you.
Those two go with you. This is the one you'll return if you want. Okay. This is for your records. Okay. Make sure.
Oh, absolutely. Yeah, absolutely.
I know I have a tendency.
It's okay. I'll track you down.
Ms. Messer, anything further on this file today?
Sorry, Your Honor, nothing on this file. Thank you.
Thank you. You're free to disconnect at this time.
Thank you, Your Honor. I do have Joseph Trevor. Does the court still happen to have that one up for sentencing this morning?
Do you have that set for 10:30? We're running a little bit behind. So I've got 2 other cases I need to call to get to that one, but if you just want to stay on the line, that would be great.
Thank you so much, Your Honor.
Thank you. Mr. Dick, do you have Mr. Schneider present?
He's at USC, Your Honor. He should be agreeing by Zoom.
Mr. Farner.
Yes, sir.
Here's my copy. Sorry to put your word.
Okay.
All right, we'll go on the record in People versus Farner, file number 266992 and 266993. The record should reflect Mr. Farner is present here in the courtroom today. If I could have counsel put your appearances on.
The record number is close to file for example.
James Dick on behalf of Mr. Farner, both files as well.
Mr. Dick, can you give me a status as to these 2 files here today?
Yes, Your Honor. So we are on the eve of a resolution. I don't know, the offer was worked out yesterday, and Mr. Farner and I would request just a brief, perhaps 30-day adjournment to discuss this final plea offer and get everything.
Mr. Rolla.
Judge, yes, we did discuss, in fact, I spoke personally with this council yesterday. We're talking about 2 files, probably have 9 different files, many of them involving methamphetamine. I think the people have no objection, the cases have not been before the court all that long. We have no objection to a single adjournment, so that will, we're looking at 3 days or end of, we have no objection to 30-day adjournment to have that become 2.
Okay, so Mr. Farner, the court is going to set this for a plea hearing in July. It's important that between now and then that you stay in touch with your attorney. At that hearing in July, I'm going to be asking you for a final decision about any plea agreements. So at that time, if you want to enter into a plea agreement, we'll take your plea at that time. If you don't, then we'll set it for trial and the court will not accept any pleas to any lesser charges after that date. So it's very important that you come to that hearing ready with a final decision, okay? Do you have any questions at all?
Not this time.
Okay. So just make sure that you stay in touch with Mr. Dick, and that's all for today. Thank you. Mr. Rollo, I have John Ryder. Are you anticipating any victims in any cases?
Don't think that's gonna happen this afternoon.
Judge, that is Dawn Crow. She,
Oh, Ms. Crow.
yeah,
Okay.
I believe.
Judge, are you calling Don Ryder's case?
Is that your case, Mr.?
It is, Judge.
Okay. We're a little early on that one. Are you ready to go?
Actually, my client called me. She's kind of in a panic. She told me her muffler is reattached and she's on her way. But she says she'll be here, and I think maybe around 11. I don't know if the court can indulge in that, but she's trying to come.
Okay, yep, that's fine.
Okay, thanks, Judge.
You might want to give her a call because she's signed in, but just let her know. Just like,
Okay, I'll let her know.
in person. Yeah.
All right, thanks, Judge.
Thank you. Mr. Villa, in the Schneider case, do you know if we got a writ in that one?
We did, in fact, I just got confirmed that a moment ago. Writ was done on May 7th. And
I do have a confirmation on that one.
oh, here you go.
Um,
Confirmed on May 26th.
yeah,
And the writ
DR.
was for June 3rd, 2026 at 10:15 a.m.
Yeah, and DOC.
So,
Just says DRF. I do have a coordinator phone. Do you want me to try that?
all right, let's take a brief recess. We'll come back on the record in just a couple of minutes.
All rise.
The writ sent to AOC, which means they're probably gonna honor it. Although we have had And hopefully it's not, you'll get the call, oh, we forgot, we have a outbreak of COVID or whatever else it is, and they are now in quarantine lockdown. Well, you know, a phone call would be nice. Well, you know, we have this going on. That's the best one that we had last year. Well, we're looking for the defendant. We don't know where he's at. And so I, right on the screen, it says, do you have the jailbreak alarm going off? We know he's here somewhere. We're just not sure. And some of the facilities are better than others. There's a couple, Carson City is not a good one. No, that's a good thing. Or Huron Valley for women. That's another one that there's problems with. It's a good thing you don't know where that is either. It's down by Saginaw.
I was wondering, I know the Huron area.
Huron County.
Orange prison. Assuming.
That and then as far as county jails, probably Wexford County, that's Cadillac, is probably the worst one to deal with.
Okay.
Probably.
Really?
Yeah, they're horrible. They don't even answer the phones.
I heard there's a lot of crime.
Alan Jacob
Huh?
Schneider.
I heard there's a lot of crime.
There's a lot more now.
Yeah.
Well, it's funny, there's like two Cadillacs. It's kind of like Petoskey. You have old Cadillac and new Cadillac. Because with the construction and stuff going through, it's really got it divided.
Yeah.
Okay.
Yeah.
But at least you don't have to go all the way around through Lake City to get there now,
Mhm.
because the bridge was out for a while there.
Yeah, I just drove through there like 2 days ago. The Cadillac area.
I was down there 2 weeks ago. I had to go all the way to Grand Rapids
Ooh,
for the Court of Appeals.
really?
Yeah.
I like Grand Rapids.
So it's 3.5 hours down, 3.5 hours back for maybe 11 minutes of oral argument.
Oh, well, that's beautiful.
But they wouldn't let me appear by Zoom.
Why?
No, the weather's nice. There's no need for you.
Oh, that's why. That's the reason.
That's the only reason they'll give you is because of a weather emergency. Otherwise you have to be in person. So now I can check off my list. I've been to every Court of Appeals in Michigan.
Really?
Yep, Detroit, Saginaw, Lansing, and now Grand Rapids and Marquette.
Which one's the best?
Oh, and Traverse City
All right,
on
thank
special
you.
appointment.
Really?
Oh, the one in Lansing's it's got the best facilities and the rooms are the largest. Some of the other ones, it's like
Hi,
you're
this is
in a
Leanne.
shoebox kind of thing.
Yeah.
I mean, the whole room is maybe from
with you
there
guys.
to about here. And you've got the judges and they kind of like squeeze in next to each other. And then you've got 2 rows of benches, but there's like maybe this much in between them
Yeah.
and about the same amount on the side.
Yeah.
Not really good.
No, no.
Yeah, now I've been before the Court of Appeals 42 times, Michigan Supreme Court 8 times, federal courts twice,
That's cool.
changed law twice.
Really?
Something many attorneys never do in their entire career. I've done it twice.
I worked at the House of Representatives in Arizona. I did an internship last semester there. So that was crazy. But I went to Supreme Court twice. Yeah. It was cool. It's really cool.
So I got to do the tour and go into the upper dome where the public's not allowed.
Yes.
You get to see snipers perches and stuff.
Yeah. Mhm. Yeah, it's the Capitol there. The old Capitol is cool. But the
Yeah, I
building-
agree.
The building I worked in,
Well, we were gonna do the Washington Monument, except it was closed for repairs.
really,
I go to New York, the Statue of Liberty is being repaired. I go to DC,
that's such
Washington
a
Monument.
bummer.
It's like, what a bummer.
That's such
But
a
that's okay.
bummer.
We spend more time at the Smithsonian and I,
Did you?
which is kind of,
Yeah.
you could spend 2 weeks there and not even see
Oh,
it.
yeah. Yeah, I wanna go there.
Except, and it's a lot better now than it was 10 years. 10 years ago, you had groups of all in and all sorts of.
Yeah. Ugh. Makes me think of, the Night of the Museum movies.
Yeah,
That's what that makes me think
yeah,
of.
yeah. I can see that.
Yeah.
It's like cat.
That's the. So,
Yeah, last year I had 16 appellate briefs I had to do,
Really?
16 separate cases. Year before, only 4. And
Really?
they take anywhere from 100 to 200 hours a piece to do. So you're talking anywhere from 1,600 to 2,800 extra hours last year alone.
That's insane.
Yeah, I put in better than $4,000 last year.
That's insane.
No, what's insane is my wife reminds me, and Mike, you know, you haven't had more than 2 days in a row off since the end of February 2023.
Really?
Yep. Not by choice. We tried to schedule things,
Yeah.
but whether I've been summoned for appellate courts and circuit court murder trials that I couldn't the jury.
Yeah.
What are you gonna do, you know? Well, we finally got in a circumstance where the law has now changed, where the prosecutor puts in with at least 2 months' notice, time they're gonna be gone for vacation, the court can't schedule things at that time.
Really?
The fact that we had to have that put into law is pathetic. The defense bar gets it left and right. Because,
Really?
well, then there's gonna be an appeal and they deny appropriate counsel, insufficient counsel. And it's like, oh, but it's okay, the state can get denied it, and then that's fine. So
So
we
do you ever
finally,
go on vacation?
I have vacation planned this year.
Really? Good.
In-
When?
in
Where are you
August.
going?
No, I'm not telling anybody.
Oh,
No, that's like, no, my phone's gonna be disconnected. I am gonna be
Okay.
unavailable.
that's good. No, that's good.
I'll find a way to get you.
No, you won't. You can look, but you won't find me. Not where I'm going.
Will you tell me if it's out of the country? Is that out of the
I neither confirm nor deny that statement.
That's good though, that you get a vacation. How long?
One break is 9 days, and the other break is 5 days.
Okay.
One's for a niece's wedding that I have to be down for, out of state.
Yeah,
The other one is my time.
good.
Did you get them?
Yeah, it's count time, that's, and so they're gonna work on getting them in there.
The last time when I told where I was gonna be on vacation, I was actually doing felony warrants, search warrants, from downstate. Because the person who's on call, for some reason, could not be reached. Apparently, their phone died. They didn't plug it in. That was the story I got.
I don't believe it.
Yeah, well, I wasn't buying it either. I know, because I had an officer go to their home and check out.
Oh, really?
Yeah, after I did this stuff, I said, I want to go down though. Put it on the chart. Didn't they just do the other HE insurance?
Yeah.
Oh, okay, well, that's a good reason.
Yeah.
Let's say, if he's here, we'll do it, you know?
Yeah.
Get it on, John.
All rise.
Please be seated. Mr. Dick, were you ready with Mr. Trevor's case?
Yes, sir.
Go on the record in People versus Trevor. This is file number 256950. The record should reflect that Mr. Trevor is present here in the courtroom today. If I could have both counsel put your appearances on.
Ashley Messer for the people, Your Honor.
James Dick on behalf of Mr. Trevor.
Thank you. This is the date and time set for sentencing in this matter. Mr. Trevor, have you had an opportunity to go through the pre-sentence report with Mr. Dick? Yes. Mr. Dick, are there any additions, deletions, or corrections to that report?
No additions, deletions, or corrections to the body of the report, Your Honor.
Are there any challenges?
That was good. When the jury or the UPS driver where it says the new job is a new job, I was let go because of I was on disability.
Perhaps, Your Honor, one thing that would be changed would be CFJ 284, page 6, under employment. The UPS job, it did say new job. He ended up,
I was fired on was on disability.
Okay. Let go because of disability.
I went from short term to long term. I had a shoulder repair, and in between, because it's insurance purposes, right? You have short term, it only goes 6 months, and then long term starts from 6 months and it can go on like indefinite. Well, from the 6 month checkup, there was rescheduled for that appointment, and it sent back a 3-day no call, no showed me, and then I didn't know. They like next day aired me my termination paperwork, and I just didn't fight it with the union.
Okay.
termination when it would be appropriate.
Okay, so we'll indicate that that was terminated. Ms. Messer, do you have any objection to that change?
Not at all, Your Honor. Thank you.
Any other corrections?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
There are none.
Ms. Messer, do the people have any additions, deletions, or corrections?
No, Your Honor. Thank you.
Challenges to the scoring?
No, Your Honor. Thank you.
All right, and I did read, I know the victim did provide a statement, which was in the PSI that I read. Do you have anybody who wants to address the court here today?
Your Honor, if I could just inquire whether or not my victim is in the courtroom. Her name is Casey Atchison.
I do not believe so.
Thank you, Your Honor. I appreciate that. Court checking.
Okay, anything on behalf of the people for allocution then?
Yes, Your Honor. Mr. Trevor did agree to assign his bond of friend of the court to sort of earn the delay of sentence agreement. I think it's appropriate for the court to adopt our sentence agreement and place Mr. Trevor on a delay of sentence and give him that opportunity to earn the benefit of the bargain and potential reduction of these charges should he continue to pay down his arrearage and fulfill his monthly obligation.
Thank you. Mr. Dick?
Yes, Your Honor. So we would also ask that the recommendation be adopted. However, just on behalf of Mr. Trevor, Your Honor, he did, for lack of better terms, he did rack up a significant amount of arrearages. He's had a couple of periods where he had been injured and out of employment during these times. Presently, he is back to work following another injury last year. He is now working in his own company doing excavation He has work lined up and anticipates that it is going to be continuing forward, which will allow him to make these payments and these obligations. At present, he does acknowledge that he is behind and takes ownership of it. However, he is also asking the court to take into consideration that he is just more recently, the past couple months, getting back to work on a regular basis and generating some income. He is working towards, well, he has some accounts that are due in presently. He will be able to start making payments on everything here once those accounts are paid. Today, Your Honor, we would just ask that the court does consider sentencing agreement and allow Mr. Trevor to abide by the terms of it going forward beyond today.
All right, thank you. Mr. Trevor, anything you wanted to say today?
No, I just, I mean, I guess I appreciate the opportunity to be able to, you know, pay my debt, I guess. You know, it was never, there's no ill intentions of not paying the debt, right? You know, that's a big priority. It's just a line of, you know, unfortunate circumstances with injuries, and some legal battles and stuff like that kind of made things very difficult. Yeah, trying to get everything squared away here the best we can.
Your Honor, my apologies. I did leave one point out that I wanted to just address briefly.
Sure.
So there's a statement from the mother of the child that the payments are due to in the PSI. The statement does appear to have a copy and paste of a portion of some deposition from time. I just would ask that the court takes that little excerpt with a grain of salt, as it is not a complete presentation of the circumstances above or below those couple statements. And other than nothing else here. Thank you.
All right, I did read through the report, so I'm familiar with all the information contained within that report, Mr. Trevor, about what brings you before us here today, as well as your past history and circumstances and so forth. And I take that into consideration along with what the attorneys had to say and what you had to say. Of course, what the victims had to say. And clearly, she has been impacted by your failure to pay, and this is a fairly large arrearage that you've developed. So it's a significant amount of money that mothers had to go without and had to provide for the child, regardless of what's been happening with you. None of the other things stop just because you're injured. And, you know, I don't know what the rest of that transcript says. I only know what she has stated and copied or pasted in the report. I can tell you though, I mean, I'm familiar with friend of the court interactions with you. They've been difficult. And I want you to clearly understand that I'm not going to play patty cake with you on this. This is a delayed sentence. I expect you to make the payments as you're required to make. And if you don't, there's 9 months of jail within the guidelines that I can impose. I can tell you right now, no qualms to have you sit in jail for 9 months. Because if you're not paying, the only reason why I'm not imposing jail, why we're doing this deal now, is to try and get you to pay. If you're not paying, there's no reason why you should just sit in jail. So I don't care what effect that has on business or anything else, because at that point, you're going to have said in so many words that there are other things that are more important than making these payments. So I just want you to understand that from the outset. There's going to be very little leeway for you by me if you're not complying with the terms honors this delay. As it is, though, I think it's appropriate to go forward with that as the agreement. And so the court is going to place you on a delayed sentence for a period of 1 year. The court is going to adopt as the terms of that delay all the terms and conditions listed within the report. I know the report indicates 9 months of jail held in abeyance. I don't think I can impose that because this is a delayed sentence. So technically, this isn't a sentencing hearing. However, if there isn't compliance, we will be back for a sentencing hearing, and the court will impose that time. The court is going to order as the conditions of your probation that you pay child support as ordered. The court is going to require that you pay a crime victims assessment of $130, a supervision fee of $30 per month while you're on the delay. The court is going to preserve, again, because we're not at a sentencing hearing, I'm not going to make court costs or attorney fees a requirement of delay. I'd rather have that money go towards the child support. However, the court is required to impose the DNA testing fee of $60 and a $204 state cost. Again, because this is a delay, there are no appellate rights. Ms. Davis, are you going to meet with Mr. Trevor here today?
He just needs to contact Agent Vertical.
Okay, so you just need to make contact with Justin Vertical, who's the one that did the pre-sentence report. Is there a particular time that we need to have?
He's in the office all day today.
Okay, so just contact him before the end of the business day today. Ms. Messer, is there anything further we need to address today?
No, not from the people's perspective, Your Honor. Thank you.
Okay, Mr. Dick,
No, Your Honor. Thank you very much.
good luck to you going forward, Mr. Trevor.
Thanks.
Thank you so much, Your Honor.
Thank you. And Ms. Messer, you're free to disconnect at this time.
Thank you, Your Honor.
Mr. Dick, we have Mr. Schneider connected. Mr. Schneider, are you able to hear me okay?
Yes, I can, Your Honor.
All right, we're on the record in People versus Schneider, file number 266991. The record should reflect Mr. Schneider is appearing today by video from Michigan Department of Corrections. If I could have counsel put your appearances on.
James Dick on behalf of Mr. Schneider, Your Honor.
Thank you. Mr. Dick, can you tell me the status of this file here today?
Yes, Your Honor. Mr. Schneider, please correct me if I'm wrong, but today we were planning to enter a plea based on the offer that was made at the district court level. That plea would be to count to possession of methamphetamine in exchange for dismissal of the other counts, Your Honor.
All right, Mr. Schneider, were you able to hear that?
Yes, Your Honor. Yes, correct.
Is that how you wanted to proceed today?
Yes, Your Honor. It is.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Schneider, are you currently, is this, Mr. Dick, is this plea going to affect any kind of parole or anything?
This one shouldn't. This incident occurred before the other ones that he's presently in there for.
Okay. All right. So, Mr. Schneider, you understand the maximum possible penalty that you could face for this charge of possession of methamphetamine is up to 10 years and or a $15,000 fine?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
I plead guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, Your Honor, I do.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor, they have not.
Has anybody promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, so do Your Honor.
Are you pleading guilty because you are actually guilty of this charge?
Yes, Your Honor.
The information I have indicates this happened back on February 11th of 2025. Is that the correct time frame?
Yes, Your Honor, it is.
At that time, were you present here in Otsego County?
Yes.
And while you were here in Otsego County, you had possession of some methamphetamine.
Yes, I was, Your Honor.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
No, Your Honor, I did not.
All right, thank you. Mr. Dick, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Roloff?
Yes, Judge, thank you.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
None by the people, thank you.
None, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Mr. Schneider, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing. And between now and then, someone from probation will be in touch with you to complete a pre-sentence report. You have the right to have that sentencing hearing in person here in Otsego County. And so if you wanted to exercise that right, I would sign an order to have you transported here for that hearing. You can waive that right and we can have that hearing by video as well. Do you know how you'd like to proceed in that regard?
I'll just waive it. We can do it by video, Your Honor, if you like.
Okay, so the court will set this for sentencing by video, and Mr. Roloff, your writ can reflect that.
Very good, Judge.
Mr. Schneider, do you have any questions about your case?
No, Your Honor, I don't.
Okay, thank you. Then that's all for this hearing today, and the court's going to disconnect.
All right, thank you. Have a good day.
Is Mr. Gantz present?
Yes, Your Honor.
Mr. Gantz, you come forward, please. This is People versus Michael Gantz, file number 2669998. The record should reflect that Mr. Gantz is present here in the courtroom today. Executive counsel for your appearance.
The record, John, my own man, people.
James Dick, on behalf of Mr. Getz, who is standing to my right, Your Honor.
Thank you. Mr. Dick, how do we want to proceed in this file?
Your Honor, I believe this is the first circuit court hearing. We are still in plea negotiations, and I did speak with Mr. Rella about this case and I believe that he is okay with asking for a brief adjournment for this matter.
And Judge, we did discuss the plea offer yesterday. There's a plea offer and pleas to the counts 2 and 3 for the dismissal of the remaining counts. If defense counsel needs more time to have that discussed and then subsequently answered by his client, people objection.
Okay. So we will set this for a status conference plea hearing in about 30 days. So Mr. Gantz, between now and then, you need to make sure that you stay in touch with your attorney, that you discuss any plea offers with him, and that you come ready with a decision on that at that next hearing. If you decide to enter into a plea agreement, then we'll take your plea at that time. If you decide that you don't want to enter into a plea agreement, then the court will set it for trial, and we won't accept any pleas to lesser charges after that date. So it's very important that you come to that next hearing with the final decision.
Yes, sir.
Do you have any questions about that?
Judge, for the record, plea offer specifically is plea to counts 2 and 3 as a conditional second for dismissal of the remaining counts and the higher provisional assessment. Thank you.
Is that consistent, Mr. Dick, with what you're understanding?
Yes, Your
Oh. Mr. Cantz, do you have any questions?
No, Your Honor.
Thank you, that's all for today.
Thank you, sir.
Mr. Matisse, do you have either Miss Ford or Miss Crowe present?
Mr. Ford, I believe is, attending by Zoom on this hearing, Judge.
Is that something that we set up at that time?
I thought, the court sent him Zoom instructions when I talked to him on the phone, and so I thought that's how that was working. If I'm misunderstanding, Mr. Ford is one of these guys. I thought that was arranged because he works, out of state. That's why he has that bond condition. He's working in Kentucky as a travel nurse.
Okay. All right, Mr. Ford, are you able to hear me okay?
Yes, sir.
All right, we're on the record in People versus DeAndre Ford, file number 266995. The record should reflect defendants present by Zoom video. If I could have counsel put your appearances in.
Good morning, Your Honor. Gabriel Matisse on behalf of DeAndre Ford.
Court adjourned, my problems, asking people.
Mr. Matisse, can you tell me the status of this file here today?
Judge, if Mr. Roller could please put the offer on the record. We have a resolution.
Yes, Judge, there's an offer of, has a defendant plead, but with a agreement of sentencing under 333.7411.
I'm sorry, can you say that again?
Yes, Judge, that would be to enter the plea as charged with us under 7411, 333.7411.
Okay, so to both counts.
Correct, Judge.
Mr. Matisse, is that your understanding as well?
That is your honor.
Mr. Ford, is that the agreement that you've discussed with your attorney?
Yes, sir.
And is that how you wanted to proceed today?
Yes, sir.
Okay, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Thank you. You can lower your hand. Mr. Ford, are you currently on any kind of probation or parole?
I'm out on yeah, I think I'm out on parole.
Bond, Judge.
Okay. Mr. Matisse, are you aware of any probationary or?
No, he doesn't have anything else going on. He's on bond, Judge.
Okay. All right. And Mr. Ford, do you understand that by pleading guilty to count 1, which is possession of cocaine, the maximum possible penalty you could face would be up to 4 years and or a $25,000 fine?
Yes, sir.
And the maximum possible penalty for count 2, which is open alcohol in a vehicle, that is a misdemeanor of 90 days and or a $100 fine. Do you understand that?
Yes, sir.
Thank you, Judge. I apologize.
Okay. With those maximum penalties in mind, what is your plea to each of those charges today?
I plead guilty.
Great. Right now you have certain rights. I'm going to go through those rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to these charges because you are actually guilty?
Yes, sir.
The information I have indicates that this happened back on April 8th of 2026. Is that the correct date?
Yes, sir.
On that date, were you present here in Otsego County?
Yes, sir.
While you were here in Otsego County, did you have possession of some cocaine?
Yes, it was in my car. Yes, sir.
All right. Did you have any legal right to have any amount of it at that time?
No, sir.
Did you also have an open container of alcohol at that time?
Yes, it was some empty beer can that was in a trash bag in the back seat. So yes, sir.
All right.
Nearly empty, Judge, possibly?
I don't know what the police say.
Actually, it was there was the beer can, but then there's the beer sitting in the console that was dumped out into the center console.
Okay, so, okay,
Oh,
so
she
Mr.
had the bag on the stand. Yeah, she did have the bag on the thing that you. Yeah, my sister was driving. Yeah, it was in the front seat in the bag, in the trash bag.
And it was open?
Go ahead.
So may I judge, was it open and was there alcohol in it?
It was an empty can.
So was there spilled alcohol within the console?
A flash, yes, sir. It was. I'm sorry. Yeah, it was a flash. I forgot about the flash was in the back seat too.
Yeah. All right. Okay, so Mr. Background. Okay. Counselor, are you both satisfied with the factual basis?
I am, Judge. People are not satisfied. Thank you.
Thank you. Counselor, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
Never mind, Judge.
Not by the people. Thank you.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
That's right.
Mr. Ford, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. The court will set this for a sentencing hearing. There's a couple issues that we need to address because Mr. Matisse, while we were going through the hearing, I got a note that Mr. Ford's mail is coming back to the court.
Oh, okay.
We need a good address for Mr. Ford.
Mr. Ford, do you have an address? I know, so Mr. Ford, you're a traveling nurse. Do you know where we can get you mail and get it done securely?
Yes, sir. I had faxed the paper over with the current address. It was the 760 Dutch Colony Drive, Cincinnati, Ohio 45232.
Dutch Colony Drive.
Can you spell that, the name of that street for us?
Yes, it's 760 Dutch DUTCH Colony COLONY DR for Drive, and the city is Cincinnati, Ohio, zip code 45232.
And Ms. Davis, do you want Mr. Ford to contact you or do you want contacted?
Yeah. Do you have a good phone number for him? I'll get that from.
I have a phone number, yeah.
And then we'll call him.
Oh. So Mr. Ford, somebody from our probation department here is going to call you. Mr. Matisse is gonna give her your phone number.
Yes, sir.
It's important that you follow up with that phone call.
I
And
will.
it's an order of the court that you comply with that process of, she's gonna prepare a pre-sentence report and she needs to talk to you about that, okay?
Yes, sir.
All right, and then this matter will be set for a sentencing hearing here in Otsego County. So Mr. Ford, you're gonna need to make arrangements to travel here for that hearing for sentencing. You understand that?
Yes, okay. I'll make preparation too.
That will be in person. So if you try to sign on by Zoom for that hearing, I will not count that as an appearance, okay? You need to be here in person.
I will, sir.
Okay. All right, Mr. Matisse, anything else that we need to address in this case?
No, nothing further at the moment, Judge. Thank you.
Mr. Rowland.
No, thank you.
Mr. Ford, do you have any questions about how we're going to proceed with your case?
No, sir.
Okay, thank you. That's all for this hearing today, and you're free to disconnect at this time.
All right, sir.
You know if Ms. Crowe is joining. I
It looks like she just brought me, just a moment ago, Judge, I think she said this is when she's gonna be here. So I think she is. Also, Judge, I have chance though, case, and I was wondering if he and they brought him over from Wexford County, would have a moment to discuss the pre-sentence investigation
Yeah.
report.
If we can have Mr. Donald brought over here to the
That would be perfect.
hearing box, and I'll give you a chance to meet with him briefly.
Thank you.
And then we'll come back on. Okay, we're on the record in People versus Donald, file number 266976. The record should reflect Mr. Donald's present here in the courtroom today. And I'd like to have the council put your appearances on.
Thank you, Your Honor. For the record, my call behalf of people.
Gabriel Matisse on behalf of Chance Donald, standing to my left.
Thank you. This is the date and time set for sentencing in this matter. Mr. Donald, did you have an opportunity to go through the sentencing report with Mr. Matisse?
Yes.
And Mr. Matisse, are there any additions, deletions, or corrections?
We have no additions, deletions, corrections, or edits to the PSI report here.
Thank you. Are there any challenges to the scoring of the guidelines?
No, Judge.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor, thank you.
Any challenges to the guidelines? Anything by way of allocution on behalf of the people?
Judge, this is the first felony situation, so the guidelines are 12 to 20. The significant concern of this particular case is the amount. We have 8 ounces of meth, separated bags. Obviously, that would generally imply something that's not used because of the amount of methamphetamine. In that case, there's a recommendation 3 months with 7 days credit. Obviously, sentencing is up to the court.
Thank you, Mr. Matisse.
Thank you, Your Honor. As you can see, my client is young. He's a young guy. He's actually quite respectful. He's intelligent and he's enterprising. He doesn't have a drug addiction, and this is one of the silver linings in this situation. He simply made bad choices. He got into selling drugs. He's serving a sentence in Calcasta now. And I've talked to him about it, and this is just about making new choices moving forward. He can turn this around. He knows what he did was wrong, and he doesn't want to be locked up anymore. He's realizing this isn't getting him where he needs to go, and he's only 18, Judge. He needs to make new decisions, and he understands that. He's cognizant of what he's done. So I'd ask the judge, I'd ask the court to please adopt the lower end of the recommended guidelines if at all possible.
Great, thank you. Mr. Donald, anything you wanted to say today? So Mr. Donald, I read through the report. You know, we've already seen each other in Kalkaska County, so I'm familiar with your background and your circumstances. Obviously, I'm familiar with what happened in that case, which is very similar to what happened in this case, where you were selling significant amounts of methamphetamine, 53 grams, as Mr. Rolla indicated, at 8 ounces, almost half a pound. That is a lot of methamphetamine. Certainly at the higher end, I've been doing this for 13 years, and at the higher end of any case that I've seen. And so you are somebody who comes to the court as a young man without, other than the Kalkaska case, any kind of record, but you jumped into the deep end. I think I told you that before, Kalkaska. I think you're very lucky, given the amounts of methamphetamine that you're dealing with, to avoid going to prison on your first time, just by sheer weight that you were handling. I do think that you've got some growing and maturing to do. I don't think you're looking at things in a fully adult way, and I don't think that's unusual or abnormal. I hope that you take some steps to do that. You know, you sent me a letter in reference to the Kalkaska case about 2 weeks ago in May, and I read through that letter, and one of the things that struck me about that was your statement that the system saw me do wrong 2 times in the same day and didn't stop me when they could have. And so, you know, for you to be looking at this like, well, the police just kept letting me sell methamphetamine when they knew I was doing it, that just to me speaks to the kind of level of immaturity that you're at right now, when you think that you can sell methamphetamine as much as you want, and then it's up to the police to stop you from doing it more, instead of letting you continue to sell and then holding you responsible for what you're doing. And I saved that and I highlighted it because I wanted to point out to you that that's just not the right way to look at this. You shouldn't be selling methamphetamine in the first place. And it's not up to the police to tell you to stop doing it. It's up to you to not do it. And so I think you've got a lot of learning to do, and I hope that you do that. I hope you've got some people in your life that can help you start to look at things from a more mature standpoint, and that as you get older, that you do. and that you don't repeat this, because if you continue to be involved in selling these kind of amounts of methamphetamine, you are going to end up in prison for a long period of time. In this case, I think, again, given the sheer amount that you brought into this community, a sentence of 11 months in the Otsego County Jail is appropriate, with credit for 3 days served. The court's going to order that that be served concurrent with your Kalkaska County sentence, so they'll be served at the same time. The court is going to order restitution in the amount of $600. That's to be paid to the Otsego County clerk to be dispersed to Straits Area Narcotics. The crime victims assessment of $130, court costs of $325. Matisse, are you appointed or retained?
I'm appointed, Your Honor.
Okay. So attorney fees of $350 and a $68 state cost. You do have the ability to seek an appeal of this sentence, and Mr. Matisse, you can provide those appellate rights to Mr. Donald. Right, Mr. Donald, you are remanded to custody at this time.
So sorry. Sorry, we have to initial one more on this.
I've got this one, so
Okay.
that's just for food.
I'll get them to take that.
Do we have Miss?
We do. She's here, Judge.
Cropping forward, please.
Sorry, Anthony.
Well, you did the right thing and let your attorney know, so that was a good thing. Record in People versus Don Crow, file number 2669. Where Mr. Crow is present here today. Thank you for your appearance.
People.
Gabriel Matisse on behalf of Ms. Crowe, who's standing to my left.
Okay, Mr. Matisse, how did we want to proceed in this case?
Judge, we submitted some information a while back to the prosecutor, and could the prosecutor please put his offer today on the record for us?
Yes, Judge, there's an offer plea to count 1, which is a police officer resisting obstructing, and count 5, domestic violence. In return, the other 3 counts of resisting obstructing will be dismissed.
Was that your understanding, Mr. Matisse?
Yes, Your Honor.
Ms. Crowe, is that the agreement that you've discussed with your attorney?
Yes, sir.
And is that how you wanted to proceed today?
Yes, sir.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Ms. Crowe, are you currently on any kind of probation or parole?
No, sir.
Right, and you understand that by pleading guilty to resisting or obstructing a police officer, that carries with it a maximum penalty of up to 2 years and or a $2,000 fine?
Yes, sir.
And that domestic violence carries with it a maximum penalty of up to 93 days and or a $500 fine. Do you understand that?
Yes, sir.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify to trial yourself if you want it. Do you understand all those rights?
Yes, sir.
Do you understand that you're going to be giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty?
Yes, sir.
The information I have indicates this happened back on April 5th of this year. Is that correct?
Yes, sir.
And let's see, did this occur at your house?
Yes, sir.
Okay. What's the address of your house?
2941 Pine Grove Road.
Is that here in Gaylord?
Yes, sir.
And did you have an altercation with Donald Rowe?
Yes, that's my father.
That's your father, okay. And you reside in the same house together?
Not anymore. We used to.
Did you at the time of this?
Yes, sir.
And what did you do that would be an assault?
I pushed him. He was in front of the door, locking the door between me and my child. I was in fear for my child, so I pushed him out of the way.
All right, did police respond to
Yes,
that?
sir.
Okay, and was one of those officers a deputy from Otsego County?
Yes, sir.
Did that officer have his uniform on?
Yes, sir.
Did you know that he was there performing his duties as a police officer?
Yes, sir.
Did the officer give you some commands or what happened to the officer?
The officer gave me commands. He told me not to leave. I told him I wasn't in my right mind. I wanted a mental hospital. That I wasn't mentally stable. So I told him I was going to leave. He told me not to. I proceeded to walk to my car. He was going to detain me. I was combative because I didn't understand why I was being detained. Because I didn't want to leave. I just wanted to sit in my car. And I was kind of mean to the officer.
That happened at your residence also?
Yes, sir. I'm very sorry.
Counsel, do you both agree that there's a factual basis as to each of these charges, Mr. Rolla?
He was satisfied the court is sufficient factual basis to accept the defendant's guilty pleas as to both counts 1 and 5. Thank you.
Mr. Ortiz.
The factual basis has been met, Your Honor, thank you.
Thank you. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Judge.
Are you both satisfied that the court has complied with statute and court rule in taking its plea?
He was satisfied. Thank you.
I am, Judge, thank you.
You, Ms. Crowe, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to each. We're set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with your attorney between now and then so that you're ready to go forward on that day.
Okay.
Before you leave today, you're going to meet with Ms. Davis for a pre-sentence interview to set that up.
I do have a question. Is there any way that I can ask, instead of going to having jail time, to go to a mental hospital? I just found out I'm pregnant and I really just want to better my life for my child.
So that, we'll talk about that at the sentencing hearing. That's not something that we would talk about today, but talk to your attorney about that, and some of that information you'll be given to Ms. Davis. Okay. You have any other questions?
No, sir.
Thank you, that's all.
Thank you, Judge.
All right, that concludes the morning docket. Mr. Batiste, can you approach real quick?
Yes, sir.